Every crime leaves a shadow. Welcome to the Dark Archive.
Julie Jensen did not leave behind a mystery. She left behind an accusation. 12 days before she died, Julie wrote a letter intended for the Pleasant Prairie Police Department. She sealed it inside an envelope and gave it to a neighbor with instructions to deliver it if anything happened to her. Julie did not claim that she could prove her husband planned to kill her, but she named him as the person police should investigate first. She said she had discovered things that frightened her. She said she would never willingly abandon her children. And on December 3, 1998, Julie Jensen was found dead inside the home she shared with her husband Mark and their 2 young sons. Mark maintained that Julie had taken her own life. Prosecutors would argue that he poisoned her with ethylene glycol, sedated her, and finally suffocated her. Julie's warning would help shape the case against him. It would also create a constitutional problem so serious that his first conviction would eventually be thrown out. This is the Julie Jensen case. In 1998, Julie Jensen was 39 years old and living in Pleasant Prairie, Wisconsin. From outside, the Jensen household looked ordinary. A married couple, 2 children, a middle-class home in a quiet community. Inside, the marriage had badly deteriorated. Julie had previously had an affair. In the letter she later wrote, she said it had happened years earlier and that she believed Mark had never forgiven her. But by the autumn of 1998, Julie's concerns had moved beyond an unhappy marriage. She began telling people that Mark's behavior frightened her. Julie spoke with a neighbor, Tadeusz Wojt. According to testimony later summarized by the Wisconsin Court of Appeals, Julie told Wojt that she suspected Mark might be trying to poison her or destabilize her psychologically so that he could take their children away. She said Mark had encouraged her to drink wine in the evenings. She described finding syringes. She also said that the family computer had been left displaying information about poisoning and that she had found suspicious material inside Mark's business planner. Julie did more than confide in a friend. She began creating a record. She photographed part of the planner. She contacted Officer Ron Kozman of the Pleasant Prairie Police Department. She told him that she had become suspicious of Mark's behavior and feared that if she died, her death might be made to appear self-inflicted. Julie also spoke to her son's teacher and to other people around her. These conversations would later matter because the law treated private warnings differently from statements deliberately prepared for police. On November 21st, Julie wrote the letter that would become the central object in the case. She addressed it to law enforcement. She described the material she had found and said that if anything happened to her, Mark would be her first suspect. She wrote that she would never take her own life because her children meant everything to her. Then she gave the sealed letter to her neighbor for safekeeping. Julie was not presenting herself as a detective. She did not claim to know exactly what Mark was doing. She was documenting fear. That distinction matters. She was trying to make sure that if she died, investigators would not begin and end with the easiest explanation. But a record is not protection. 12 days later, Julie was dead. December 3, 1998. By the morning of December 3rd, Julie was gravely ill. Mark later described her as barely able to sit upright and unable to function normally. No ambulance was called while she was alive. No doctor was summoned to the house. Mark left to take one of their sons to preschool and later completed a work-related errand. That morning at approximately 7:40, the family computer was used to search for information about ethylene glycol poisoning. Mark said that only minutes earlier, he had been helping Julie sit up. Later, Mark returned home with the children. He said something felt wrong and told the boys to remain outside. Julie was found dead inside the house. Mark initially suggested that she might have suffered an allergic reaction or a fatal interaction involving medication. Police searched the home and seized the family computer. The following day, Julie's neighbor delivered the sealed letter to investigators. What Julie had tried to preserve was now part of an active death investigation. The evidence. The prosecution's eventual case did not rely on the letter alone. The medical evidence was critical. At Mark's first trial, the pathologist who performed the autopsy testified that Julie suffered ethylene glycol poisoning and that he believed the immediate cause of death was asphyxia by smothering. Another medical examiner concluded that Julie had probably received multiple doses of ethylene glycol, a pattern she considered more consistent with homicide than with one voluntary ingestion. Ethylene glycol is a toxic substance commonly associated with antifreeze. Prosecutors argued that Mark had administered it over time, used sleeping medication to weaken or sedate Julie, and ultimately suffocated her. The defense presented a radically different account. Mark maintained his innocence. His attorneys argued that Julie had been depressed, had consumed the poison herself, and had deliberately arranged evidence that would implicate her husband after her death. The case therefore depended partly on how jurors understood Julie herself. Was she a frightened woman who accurately recognized danger, or had she constructed an accusation and then taken her own life? The defense theory was presented in court and had to be considered by the juries, but it was never established as fact. 2 separate juries would ultimately reject it. Investigators also recovered a troubling digital trail. Court records describe searches involving poisons and methods of causing death on the morning Julie died. The home computer was used to look up ethylene glycol poisoning. Prosecutors argued that Mark was the experienced computer user in the household and was responsible for the searches. The defense disputed that conclusion. There was also evidence that Mark was involved with another woman and had discussed a future with her. A co-worker, Edward Klug, testified that Mark had spoken about websites describing ways to kill a spouse using methods that might be difficult to detect. According to Klug, Mark specifically mentioned Benadryl and antifreeze administered over time. No single fact proved the case by itself. A disturbing search might have an innocent explanation. A coworker might misremember a conversation. An affair could establish motive, but not murder. A frightened wife could be sincerely afraid and still be mistaken. The prosecution relied on accumulation, Julie's warnings, the computer activity, the medical findings, Mark's statements, his relationship with another woman, and his failure to seek emergency help while Julie was visibly and severely ill. Julie's letter became the symbol of the case, but it was never the entire case. That would become crucial years later, when prosecutors were forced to prove the murder again without allowing a jury to read it. The first trial. Mark Jensen was charged with first-degree intentional homicide in March 2002, more than 3 years after Julie's death. The long delay before trial was driven partly by a legal fight over Julie's statements. The Sixth Amendment gives a criminal defendant the right to confront the witnesses against them. Normally, an accusing witness must appear in court, testify under oath, and answer questions from the defense. Julie could not do that. The prosecution alleged that Mark was the reason she could not, but that did not automatically make everything she had said admissible. The Wisconsin Supreme Court concluded that Julie's letter and her statements to Officer Cosman were testimonial because they were deliberately prepared for law enforcement and possible prosecution. Her private statements to her neighbor and her son's teacher were treated differently because they were not formal accusations made to police. At the time, Wisconsin applied a broad rule known as forfeiture by wrongdoing. The basic idea was that a defendant should not be allowed to make a witness unavailable and then benefit from the inability to cross-examine that witness. After a pretrial hearing, the judge allowed Julie's letter into evidence. Mark's first trial began in January 2008. The jury heard the letter, testimony from Julie's friends and acquaintances, medical findings, computer evidence, testimony about Mark's statements, and evidence concerning his relationship with another woman. The defense argued that Julie had orchestrated her own death in order to frame him. On February 21, 2008, the jury found Mark guilty of first-degree intentional homicide. He was sentenced to life in prison without the possibility of parole. It appeared that Julie's warning had done exactly what she intended. It had reached police, it had been presented in court, and it had helped establish the case against the man she feared. Then the legal rules changed. The conviction unravels 4 months after Mark's conviction. The United States Supreme Court narrowed the forfeiture by wrongdoing doctrine. It was no longer enough to show that a defendant had caused a witness's absence. To admit testimonial statements under that doctrine, prosecutors generally had to show that preventing the witness from testifying was one of the reasons for the wrongdoing. The distinction placed Julie's letter in constitutional danger. The Wisconsin Court of Appeals initially upheld the conviction, concluding that even if admitting the letter had been an error, the remaining evidence was overwhelming and repeated much of the same information through legally admissible witnesses. But Mark continued challenging the conviction. In April 2021, a judge vacated it and ordered a new trial. The ruling did not declare Mark innocent. It did not establish that Julie had taken her own life. It meant that his first trial had included testimonial evidence that he had never had an opportunity to confront through cross-examination. That can feel deeply unfair from Julie's side of the story. She wrote the letter because she feared she might not survive to speak for herself. Then the law excluded it precisely because she was not alive to be questioned about it. But constitutional rights are not awarded according to how sympathetic a defendant appears. They are limits on the government. The state would have to prove its case again, and this time Julie's letter would not be shown to the jury. The second trial. The retrial began in January 2023, nearly 25 years after Julie died. Prosecutors again argued that Mark poisoned her with ethylene glycol, administered sleeping medication, and suffocated her over a period of days. The defense again argued that Julie had taken her own life and framed her husband, but the most famous evidence in the case was absent. The second jury never read Julie's letter. Instead, prosecutors rebuilt the case around the evidence that remained admissible: the toxicology and autopsy findings, the computer searches, Mark's statements to other people, evidence of his relationship with another woman, Julie's private conversations with friends and acquaintances, and Mark's conduct while she was gravely ill. The defense challenged the medical conclusions, the interpretation of the computer evidence, and the prosecution's portrayal of Julie's mental state. On February 1, 2023, the jury returned its verdict: guilty of first-degree intentional homicide. For the second time, a jury rejected the claim that Julie had engineered her own death to frame Mark. And this time it did so without reading the accusation she had sealed inside that envelope. Julie Jensen understood that fear without a record could disappear, so she created one. She spoke to people around her, she contacted police, she photographed what she had found, and she wrote a warning designed to survive her. That warning helped direct investigators toward the possibility of murder. It also became the evidence that placed the first conviction in constitutional jeopardy. The second jury reached the same verdict without it. But the legal result does not answer the more intimate questions surrounding Julie's final weeks. What does it do to a person to suspect that danger is developing inside her own home? How does someone continue raising children and maintaining ordinary routines while privately documenting the possibility of her own death? What burden is placed on the neighbor entrusted with the envelope? And what happens when a victim's final attempt to preserve her voice becomes both the emotional center of a case and something the law cannot safely allow into the courtroom? Those questions belong to Part 2.
If you're drawn to the psychological side of true crime, not just what happened, but what it did to the people left behind, you should check out my thriller novels. The Cross series blends dark psychological crime, horror, family secrets, buried evidence, and official stories that never tell the whole truth. Start with Bloodlines, Book 1 of the Cross series, at jamiefolsom.net. And if this case is holding your attention, don't forget to like this video and subscribe. It helps the channel grow, and it makes sure you know when the next case is published.
The Julie Jensen Case, Part 2. What the Case Left Behind. Julie Jensen's case is often reduced to one object: a sealed envelope, a warning written before death, a name placed inside it, but the letter matters for more than what it said about Mark Jensen. It matters because of what Julie believed she had to do in order to be taken seriously. She did not simply tell someone she was afraid. She documented it. She photographed material she found suspicious. She contacted police. She spoke to people around her. She created a chain of witnesses. And then she arranged for her own words to reach law enforcement if she could no longer deliver them herself. That is not ordinary preparation. It is what happens when someone begins to believe that surviving may no longer be the only problem. Being believed becomes a problem too. Living inside, uncertain. One of the most psychologically difficult parts of the Jensen case is that Julie did not appear to possess one clear, undeniable piece of proof. She had impressions, patterns, objects that frightened her, changes in behavior, questions she could not fully answer. That kind of fear is difficult to explain to other people. A visible injury can be photographed. A direct threat can be repeated. A broken window can be shown to police, but a growing sense that someone inside your home may be preparing to harm you is harder to translate into evidence. The danger, if it existed, was embedded in ordinary life: a glass of wine, a computer left open, a business planner, medication, a spouse behaving differently, a conversation that felt wrong. None of those things necessarily proves anything by itself. That ambiguity can be destabilizing. A person begins asking whether she is seeing a real pattern or forcing unrelated details into one. She may tell herself she is overreacting. Then another detail appears. She may decide to leave. Then she may think about the children, finances, housing, custody, reputation, or whether anyone will believe her. Fear does not always arrive as certainty. Sometimes it arrives as a series of questions that become harder and harder to dismiss. This is one reason coercive and controlling relationships can be so difficult to describe from outside. People often expect danger to announce itself clearly. They expect a threat, a confession, an obvious act, but control often works through uncertainty. The victim is left trying to interpret what is happening while the person creating the fear remains calm enough to deny it. That uncertainty becomes part of the harm. The burden of creating a record. Voice-over Julie's response was to create documentation. That may sound practical. It was also an enormous burden. To document fear, Julie had to continue observing the person she feared. She had to notice details, remember dates, preserve material, speak carefully to other people, decide what was important enough to record, and do all of that while still living inside the same household. Document on screen, camera, copied notes, sealed envelope, police business card documentation can provide clarity. It can also force a frightened person to remain mentally inside the danger. Every suspicious event must be evaluated. Every object may become evidence. Every conversation may need to be remembered later. Ordinary life begins to feel like surveillance. The home is no longer simply a place where fear happens. It becomes a scene that must be preserved. Julie's letter shows how far that process had gone. She was no longer only asking whether she was safe. She was asking what official story might be told if she died. Would investigators believe she had chosen death? Would they assume illness? Would they treat the marriage as irrelevant? Would the things she had noticed disappear because she was no longer there to explain them? The letter was an attempt to control that future narrative. It was a way of saying, do not let my absence erase what I tried to tell you. The nagbor with the envelope. Julie did not keep the letter in the house. She gave it to her neighbor, Tadeusz Wojt. That decision created another kind of burden. Wojt became the keeper of information he could not fully verify and could not safely ignore. Before Julie's death, the envelope represented a possibility. Afterward, it became evidence. It is difficult to know what someone in that position is supposed to feel. Fear that Julie may have been right. Doubt about whether the warning should have triggered more action. Guilt over what could or could not have been done. The knowledge that a private conversation would now be examined by police, lawyers, judges, and strangers. When someone discloses fear, the listener becomes part of the story whether they want that responsibility or not. They may be asked to remember exact words spoken months or years earlier. They may wonder whether they took the disclosure seriously enough. They may replay the final conversations and search them for something they missed. The Jensen case did not remain contained inside the marriage. It spread outward to neighbors, teachers, co-workers, investigators, medical professionals, lawyers, and jurors. That is one of the lasting effects of intimate violence. The harm radiates. The children. At the center of the Jensen home were two young boys. Julie's letter made clear that her children were central to how she understood her own life. She wrote that she would not willingly leave them. The prosecution treated that statement as evidence against the defense theory. But beyond the courtroom, it also reveals the emotional trap Julie may have felt she was living inside. Parents who fear a partner may also fear what leaving will mean for the children. They may worry about custody. They may worry that the threatening person will gain unsupervised access. They may worry that police or courts will view the conflict as marital bitterness rather than danger. They may worry that disrupting the household will harm the children even if staying also feels unsafe. That can create paralysis. There may be no choice that feels protective. Julie's children lost their mother. Their father was accused of killing her. Then the case remained unresolved in a meaningful sense for years. There was a charge, a first trial, a conviction. Appeals, a vacated judgment. A second trial. A second conviction. For adults, those are legal stages. For children and family members, they are repeated reopenings of the same wound. Each hearing brings the story back. Each appeal raises the possibility that the official conclusion may change. Each news report turns private grief into public argument. The legal system needs time. It needs review. It needs appeals. It needs rules strict enough to protect defendants from unreliable evidence, but that time is lived by real people. A 25-year case is not simply a long docket. It is 25 years in which a family cannot fully place the event in the past. Julia's evidence. The most painful contradiction in the case is that Julie became both the victim and a disputed source of evidence. Her personality was placed on trial, her emotional state was examined, her marriage was dissected, her past affair was discussed. Her credibility became part of the prosecution's case and part of the defense's response. The defense theory required jurors to believe that Julie had created a sophisticated accusation against Mark and then arranged her own death to support it. The prosecution required jurors to believe that her fear was genuine and that the evidence around her death confirmed it. Both sides therefore had to tell the jury who Julie was. But Julie could not answer either version. She could not explain the tone of the letter. She could not clarify what she meant by a particular statement. She could not describe what happened inside the house during her final days. She could not respond when lawyers interpreted her choices. That is what makes posthumous evidence so unsettling. A dead person's words can be read, they cannot be questioned. Context cannot be recovered completely. Tone becomes argument. Silence becomes whatever the courtroom assigns to it. The constitutional paradox. Julie wrote the letter because she believed she might not be alive to testify. The law later excluded it because she was not alive to be cross-examined. That sounds like a cruel paradox. And emotionally it is. Legally, however, the problem is real. A written accusation can be sincere. It can also be mistaken, manipulated, incomplete, or false. Cross-examination exists because the government cannot simply place an accusation before a jury without giving the accused a meaningful chance to challenge it. The rule protects innocent people. It also creates painful outcomes when the unavailable witness is the person prosecutors say was killed by the defendant. The Jensen case sits directly inside that tension. Julie's letter felt powerful because it appeared prophetic. She named the person who would later be charged. She rejected the explanation the defense would later offer, and she created the document shortly before her death. But emotional force and legal reliability are not the same thing. A courtroom must ask questions that an audience may not want to ask. Was the statement made for the purpose of prosecution? Could the writer have been mistaken? Was the defendant ever able to challenge it? Did the government satisfy the constitutional conditions required to use it? Those questions do not diminish Julie. They restrain the state. That distinction matters. The rights that protected Mark Jensen are the same rights that protect every defendant from being convicted through accusations that cannot be tested. A justice system cannot abandon those protections only in cases where the accusation appears convincing. The second trial became the answer to that legal problem. Prosecutors were forced to remove the letter and prove the case through other evidence. The second jury still convicted him. That result did not make the first constitutional violation harmless in principle. It demonstrated that the case could survive without asking the jury to rely on Julie's formal accusation. When the record survives the person. Julie's attempt to preserve her voice succeeded in one sense. The letter survived. It reached police. It shaped the investigation. It ensured that her fear could not be quietly forgotten. But survival of the record came at a cost. Her words became public property. They were quoted in court, interpreted by lawyers, summarized by judges, repeated in news coverage, debated by people who never knew her. Once a private warning enters a criminal case, it no longer belongs entirely to the person who wrote it. It becomes an exhibit. Its sentences are separated from the moment in which they were written. Its language is turned into legal categories: testimonial, non-testimonial, admissible, inadmissible, harmless error, confrontation, forfeiture. Those terms are necessary. They are also emotionally cold. They transform fear into procedure. That transformation is one of the central themes of the Jensen case. Julie tried to create a human record of danger. The system converted it into a legal object. The second verdict. The second conviction closed the central legal question for the jury. Mark Jensen was again found guilty of first-degree intentional homicide, but a guilty verdict does not restore the years lost to litigation. It does not return Julie to her children. It does not erase the first trial. It does not remove the defense theory from public memory, and it does not make the letter uncomplicated. The verdict established legal responsibility. The aftermath remained. For those close to Julie, there was no clean ending. The case had lasted too long. Too many institutions had handled pieces of her life. Too many strangers had argued over her intentions. The final sentence could provide certainty. It could not provide restoration. That is often the difference between justice and repair. A court can determine guilt. It cannot return a family to the moment before the harm. Julie Jensen did what frightened people are often told to do. She documented. She told someone, she contacted police. She preserved what she had found. She created a record, and still the record could not protect her. It could only speak after she was gone. Pause. That is what makes this case so disturbing. Not only that Julie believed she was in danger, not only that she named the man later convicted of killing her, but that she appears to have understood, before her death, that the official explanation might become another battleground. She tried to leave investigators a path. The law later had to decide whether they were allowed to follow it. In the end, the case did not depend on one sealed envelope. The second jury convicted Mark Jensen without reading it, but the letter remains the emotional center of the story because it captures the final problem Julie was trying to solve. How do you make people hear you when you fear you may not survive long enough to speak? Julie's answer was to leave a record. The record survived. She did not. I'm Jamie Folsom. This is the Dark Archive. Every crime scene leaves a dark shadow. Some begin long before anyone knows there has been a crime.